Would everyone ensure all electronic devices are turned off or switched to silent mode? And I do like to keep the flow of debate, so I'll remind everybody at the start, no you and yours, talking through the chair, and also if out of scope, no going out of scope, and I will stop you if this is happening again today. But we will continue line by line consideration of terminally ill adults end of life bill. We now come to Amendment 23 to Clause 1 in the name of Sarah Boole, which has been supported by Rebecca Paul, with which it would be convenient to consider Amendments 82, 113, 24, 83, 114, 25, 84, 115, 26, 85, 27, 86, 28, 87, new clause 5, 29, 88, 118, 30, 89, 119, 31, 90, 120, 32, 91, 121, 33, 92 and 122. I call Rebecca Paul to move Amendment 23.
Thank you, Chair. I would like to speak in support of Amendment 23 and 82 directly today. One of the major concerns we've heard from members of the public and MPs is the importance of ensuring appropriate safeguards are in place to ensure people are making genuine choices, not requesting an assisted death because somebody else has pushed them towards it. For this reason, it's vital that Clause 1, Section 2, Subsection B is as comprehensive as it can be. It currently refers specifically to coerced and pressured, which only covers the more direct kinds of influence, not more subtle ones. It seems clear to me that amendments are required to ensure this is covered adequately and to ensure clinicians are not just looking for obvious signs of coercion or pressure when considering eligibility. If I turn to the evidence we heard in January, Dr. Mullock on the 29th of January said, in terms of the bill that we are discussing, one possible weakness here is that it identifies only very obviously problematic conduct in terms of coercion or pressure exerted by another person. And actually, the kind of undue influence that might occur might be very subtle. More needs to be done to recognise that and the subtle encouragement that might take place, where a relative might frame their support for the person seeking to die in terms of, this will be better for you, and have you considered this? That is not necessarily an example of clear abuse. So when the person seeking to die then consults a doctor, they are not going to characterise what has happened to them as coercion or abuse. More needs to be done to discuss with the person whether or not they have been encouraged by the person around them. I'll now turn to the individual amendments. Amendment 23 adds the term unduly influenced into the relevant clause. It is an important addition as it is a recognised term in law. It is designed to ensure relationships of dependence are considered. In some cases, there is no bad intent, but there is a power differential, subtle as it may be. And it's important we recognise how strong it can be. A child not wanting to disappoint their parent. A wife not wanting to go against their husband's wishes. There may well be no threats or explicit pressure, and there may be a lot of love shrouding it, but the influence is there and it's strong. And that's why it is implied in probate-based cases to test whether someone has faced influence, domination or pressure, which prevents them from exercising free and independent volition in regard to the act. It has also been applied in medical decisions, including over refusal of treatment, which can lead to death. For example, there was a case of a Jehovah's Witness who refused life-saving blood transfusion under undue influence from her mother. So it is a natural addition here into this bill. In important judgments, the courts have said that undue influence will have more impact on people who are very tired, in pain or depressed, and that a patient in a weakened condition may be unduly influenced in circumstances in which, if he had been fit, he would have resisted the influence sought to be exercised over him. This is a legal concept which could have been designed for the context of assisted dying. That is why it's important that the Boole Amendment is made. Dr. Cox, in her oral evidence on the 28th of January, said, I would say that you cannot always identify coercion. You can identify it when it is very obvious and extreme, but when it is very subtle, we cannot always identify it. After the event, there is nobody to tell us about coercion, so it is very difficult to monitor. I'd also like to point out that California's law prohibits coercion or undue influence. So there is established precedent in using this phrase in the safeguards of assisted dying law. If we have the ambition for our law, if it's to pass, to be the safest in the world, then we need, as a minimum, to add in undue influence. However, even with this additional safeguard, Dr. Spielvogel, in his oral evidence, still rather worryingly said, "I have seen many assisted dying laws go into practice across numerous states and have helped many, many people through this process. And I have never seen a case where I even suspected coercion." Richard Robinson of Hourglass, in his oral evidence, also said, "I think that coercion is underplayed significantly in terms of abuse of older people." He goes on to say, "One of the biggest issues we face is the fact that we have no ideas of the levels of training that healthcare professionals and the judiciary receive to understand and recognise coercion. That leaves us in a situation where medical professionals say that coercion in these circumstances is minimal, but people need to understand what coercion is and how to recognise the signs of it in the first place, especially bearing in mind that the vast majority of cases that we see take place in the home and by family rather than professionals." Additionally, psychiatric and legal experts have said undue influence is relevant in this context. Professor Alan House, in written evidence, refers to undue influence as coercion in its less overt or threatening forms. He also draws attention to the great risks of undue influence in the case of couples seeking assisted suicide at the same time. And the probate lawyer Tamazin Perkins, in an article on the bill, says that undue influence or coercion is depressingly common in the arena of contested wills and gifts, and suggests that the current law on undue influence could be usefully incorporated into the bill. For those that worry that adding undue influence could make things more difficult for clinicians when assessing, then I would say to them it's absolutely right on something of this gravity that rigorous consideration is given to the possibility of undue influence. I will now turn to Amendment 82, which adds the term encouraged to coercion and pressure. This amendment is in line with Dr. Mullock's advice in both her written and oral evidence. It's important to note that encouraging suicide is currently a crime under Section 2 of the Suicide Act 1961. It is also important to note that this bill does not decriminalise encouragement, only assistance. So Section 24 just decriminalises the assistance component, not the encouragement component. Thus, if it were to pass, encouragement of assisted dying would still be a crime. This is absolutely right and is something I fully support. As encouragement of suicide is clearly recognised as a heinous crime, then it surely must follow that when considering whether someone is eligible for such assistance to end their life, that consideration is given to whether they have been a victim of such a crime. This feels like a rather basic safeguard that is currently missing from this bill and must be rectified. As the former Attorney General Victoria Prentice has written, maintaining the prohibition on encouraging suicide is key to protecting vulnerable people. But it is a problem, she says, that doctors and judges under the bill are not required to check whether the person's decision is their own or whether they have been encouraged by others. She goes on to say that she hopes the committee will support my amendment and David Hughes, formerly of the Law Commission, and says that keeping the offence of encouragement would help to prevent insidious pressure.
Can an member give way?
Of course, I will give way.
I thank the
Tom Gunn.
member for giving way. I'm just wondering, in the term when she uses the term encouragement, I'm just sort of thinking about if I was in a situation where I had a loved one who wanted to access assisted dying, and I said I supported their wishes, would that fall under the scope of encouragement? Because obviously we don't want to end up in a situation where people who are supporting their loved ones end up sort of dragged through a legal process when actually it's just a case of that they're there to enable their wishes rather than actually push them to it. So how would you differentiate between those?
Rebecca Paul.
I thank the honourable member for his intervention, and I think it's an important point, and obviously case law becomes quite important on this. I think supporting someone's decision is very different to encouraging someone who wasn't in the place of wanting to go through with assisted dying. But again, like I say, these things do sometimes end up in the courts because sometimes it can be a grey line. But I think it's really important that we do have this protection here. Right now, under the law, it is an offence to encourage someone to commit suicide. So we need to recognise that. That is the law that we have right now.
Would the Honourable Lady play?
Absolutely.
Kim Ledbetter.
I think she makes a really important point there, and the idea of this is that we're taking this out of the Suicide Act and we're making an exception to the Suicide Act with this bill. And I fully support the Honourable Member's point around the supportive nature of the conversations that would take place with families, and I do think we're in danger of lacking clarity. If we use the word encourage, where does the line between encouragement and support come in? And I would like her to expand on that a little bit more if she could.
Rebecca Paul.
I thank the Honourable Member for her intervention. I think we are not trying to exempt something from the Suicide Act with this bill. We are decriminalising something that is currently a criminal offence. It is right now a criminal offence to assist someone to commit suicide. So in this, on the face of the bill, section 24, you are now decriminalising that piece. Your bill, and I totally support you with what you've done here, your bill has not decriminalised encouragement. And I would imagine you've done that for very good reasons which I support. What we don't want is people being able to go around encouraging people to commit suicide. Again, in terms of those vulnerable people that we've all talked about, it's vital that we have that protection in place. But you are absolutely right that in terms of what constitutes encouragement, can be subjective and can be difficult, but the very nature of the current law is that encouragement is already in the law, so we have to deal with this. It is already a criminal offence for encouragement of a suicide. So it doesn't make sense to not deal with it in this bill. Absolutely.
John Woodcock, I just remind everybody, you and yours shouldn't be saying
I'm
them.
so sorry.
Thank you very much, Chair. I'll do my best to abide by that. From the recollection, my recollection of the evidence given by the practitioners in California that we had present to us during the week of oral evidence, it was made very clear that, as far as they were aware, there wasn't a great deal of coercion. However, they saw what undue pressure put on by families to prevent somebody from assisted dying. Now, I personally find that incredible, given human nature, that it would only pressure would go in one way, not the other. I see what is being proposed here as just ensuring that and safeguarding people who are at a very vulnerable stage of their life. Would you speak to that?
Rebecca Paul.
Would the lady speak to that?
I thank the Honourable Member for his intervention, and I completely agree with the point you're making. It's really important that we recognise that different people will have different views on levels of coercion, and as I've already quoted some of the witnesses, I found it quite jarring that certain witnesses who have facilitated assisting dying for hundreds, maybe thousands of people are saying there was no cases of coercion. I find that personally difficult to believe. Now, I don't doubt for a second they don't believe that to be the case.
Would she give way on that point?
Kim Ledbetter.
I think my concern with that is, we had witnesses who gave evidence in good faith. I think it would be very uncomfortable if we start to question the validity or the truth behind their witness testimonies.
I think it's the intervention, and I think just to clarify, I think I just made that point. So I am not questioning that they're not telling their truth. So I completely believe from their perspective, they honestly believe they have never seen a case of coercion. Now, maybe I'm just more of a glass half full kind of girl compared to some other people, but I question whether that's really the case. I mean, I think in my 45 years on this planet, I've learned enough about humankind to know that these things do happen, and whether or not someone can detect them, different people will take a different view.
Would you give way?
Of course I will give way.
Nice shot.
I thank the Honourable Member for giving way, and she makes a very important points in the debate. Would she agree with me, and I repeat something that I said yesterday in response to another member, that actually coercion, the word coercion, the idea of encouragement, wasn't even in the vocabulary in this place until very, very recently. It was only 10 years ago. So the idea, whilst I personally wouldn't want to dismiss people's expertise, but for me it would be quite a leap of faith, and I wonder whether she shares that idea of a leap of faith, the idea that nobody, when every other jurisdiction where they do make the records of people being coerced and people being a burden, in this jurisdiction there was zero person who was coerced. I find that to be a bit of a birth of leap.
Rebecca Paul.
I thank the Honourable Member for her intervention, and I completely agree, and I think the Honourable Member has made some powerful points over the course of this committee. The reality of the matter is, like the Honourable Lady has just said, that this hasn't really been considered fully until recent times. I think we're all much more aware now of the coercion and pressure that goes on, and it's only right when we're making this decision now to be fully aware of that and have our eyes wide open to the realities. At the end of the day, what we must do here, we are not legislating for when it works perfectly for that, that ideal candidate that absolutely wants to do this for all the right reasons and they're in pain, exactly what this bill is designed for. We are legislating for that big group of people that actually are vulnerable and it may not work for. And that's a much bigger group. And I think we heard really compelling evidence from Dr. Jamelia Hussain. That evidence really impacted me, hearing that evidence about this big group of vulnerable people that could potentially be detrimentally impacted. So we must make legislation for the group that could be negatively impacted by this. They should be our focus.
I'm
very struck by that last point. And does she agree with me that the purpose of the amendment that she's supporting actually build on the principle of the bill? The bill does recognise the existence of vulnerable groups. It does attempt to introduce safeguards. It's not a free-for-all. That's the absolute purpose of the bill, is to ensure that vulnerable groups are protected. And what the amendment that she's supporting does is to ensure that the actual principle of the bill, which does say that to encourage suicide, remains illegal. And by implication of the bill, to encourage people to take an assisted suicide should be illegal too. So she's absolutely building on the principle of the Honourable Lady's bill, and I really do hope the committee will not regard this as in any way harmful to the purpose of the bill or attempting to make it more impractical in operation. It actually makes the bill clearer. And to the Honourable Lady's point about overcomplicating things, I think the complications exist in the current text of the bill. What she's doing is clarifying the purpose.
Rebecca Paul.
I thank my honourable friend for that intervention, and I think he makes the point powerfully. I would say to everyone in this committee, we had this discussion yesterday. I am not opposed in principle to the concept of assisted dying, but I see my role here to protect the vulnerable. That is what I'm trying to do, and I know you all here want to do exactly that. So I think the amendments that I'm actually putting forward today, I can't really see any downside to why you wouldn't want to include this if you want to protect the most vulnerable. The one point I would say is, yes, it maybe puts a bit more onus on the clinicians because it's a lower level of coercion that they now need to look for. But that's absolutely right. Of course they should have to do that. We're talking about assisted death. It's really important that we have a higher level. Of course.
Kit Malthouse.
I'm grateful to the Honourable Lady, and I understand that much of the difference between us on this may founder on our perception of what is actually happening. Obviously, she speaks of suicide. To some of us, certainly to me, suicide is a healthy person taking their life. What we're talking about is somebody who is seeking to take control of their inevitable death in these circumstances. And for me, those two are qualitatively different. But I am concerned about her injecting an element of jeopardy into what should ordinarily be normal conversations with one's family. So, for example, I could see a point at which, if I were in those circumstances and was thinking about seeking assistance to end my life, I would discuss that with my wife. Darling, am I doing the right thing? Is it the best thing for the kids, right? I think I'm going to have a horrible death. I'm trying to decide, right? And if we heard from families, and have heard from families over the last 10 years, very often in anguish, they support their loved one, even to the extent that they're willing to break the law. And so the line between, as my honourable friend said, support and encouragement is quite a fine one. And if a family were to come forward and say, somebody was to come forward and say, well, I've spoken to my family, they all think I'm doing the right thing. Could that not be interpreted as encouragement? And I'm conscious that we should not try to police what should be open and natural discussions between families in a way that injects jeopardy for them and for the person, to the extent that they might start to modify what they say to the doctor to make sure that they get the outcome that they want.
Rebecca Paul.
I thank my honourable friend for that very useful contribution. So firstly, I talk of suicide because we're talking about the Suicide Act. I can't do this role without not naming the actual bit of legislation we're talking about. Suicide, I know people here are a little bit squeamish about the word suicide, but it does have a clear legal meaning. Not yet, I'm finishing my point. It has a clear legal meaning, and we must not put the blinkers on with that. And I would suggest to members, if they have an issue with the word suicide, this actually is going to result in the end of someone's life. So I think we need to not be squeamish about using correct, accurate terminology in what we're describing. With respect to your second point, I think you're absolutely right. I think you make a really good point. It is a fine line and really difficult. I'm not proposing this amendment because I wanted encouragement to specifically be in here. I'm proposing it because encouragement of suicide is already a crime. I'm being logical. I'm taking what is already in the Suicide Act. It is already a criminal offence. If we don't include it in this bill, that means someone can commit a criminal offence and someone can be a victim of that criminal offence, and that won't preclude them from being eligible for assisted dying. So I am putting forward a very logical amendment, and I think you raise a great point, but if we've got an issue with the word encouragement, we need to take that up with the drafters of the suicide bill, to be honest with you. It's not as long before my time, that bill. I think it was 1961.
Will the Honourable Lady give way?
I will.
Sarah Olney.
I thank the Honourable Lady for giving way. I wonder if she'd agree with me that the value of her amendment and the value of interpreting the word encouraged into this particular piece of legislation is that, and reflecting on what the member for North West Hampshire and the member for Harrogate and Knaresborough said about the fine line argument, the value of inserting this amendment is that where it can be proved beyond doubt that somebody has encouraged, someone has actively sought to influence somebody to choose assisted death, then that is a crime and it is encoded in the law. And I think to the member for North West Hampshire's point, where it is a discussion amongst families, a discussion about possibilities, and where spouses are supporting each other in these kinds of decisions, that's not ever going to be demonstrated beyond reasonable doubt that a crime of encouragement has taken place. So the value of putting it in law is that where it can be proved, and it must be proved that that is what has taken place, and then it can be prosecuted as the criminal offence that it would be.
Rebecca Paul.
I thank the honourable member for her intervention, and as always, she so eloquently makes the point, and I completely agree with what the honourable member is saying. I'm not a lawyer, but I suspect, given the Suicide Act made encouragement of suicide a criminal offence back in 1961, I believe, I would imagine there's quite a lot of case law around that will probably help in terms of where that line is drawn on encouragement, but I would defer to better qualified people than myself on that. Of course, I will give way.
Rachel Hopkins.
Thank the Honourable Lady for giving way. It was on the point of being squeamish with talking about suicide, and may I reassure her that her sweeping statement that we're all squeamish about talking about suicide may not be accurate, because I would put back to her, how squeamish is she about talking about assisted death? Because we're actually talking about two separate things here. I would like to reiterate the points made by the honourable gentleman, that a healthy person taking their life and dying by suicide would be different to someone who is terminally ill and facing their death and ending their life by shortening their death. Would she accept that point?
I thank the honourable lady for that intervention. I am talking in terms of legal terms because I think it's absolutely right that we use the right language. So under the law, I think what you said is not correct. Now, I stand to be corrected by someone who is a lawyer, but given we are amending the Suicide Act, I think technically an assisted death it is the assistance of a suicide. I understand that you would like to reframe that and use different words to describe it, and maybe that's something that could, you know, could be done. But I think right now, under the law, it is a suicide.
I think
Rachel Hopkins.
if this bill becomes law, it would be a different situation, which is exactly what we are scrutinising today.
Rebecca Hall.
My interpretation is that it wouldn't.
No.
Just from
Mr. Giveaway?
reading, I absolutely
Yeah.
agree.
Danny Kruger.
No, not the case at all, Madam Chair. What the bill would do is to exempt people who go under this new procedure from the operation of the Suicide Act. It doesn't create some new kind of category of person. It just operates the law in a different way. And I recognise very much that she's saying that in her mind there is a difference between somebody who is dying and somebody who's healthy who commits suicide. This is a completely arbitrary distinction in reality. Many people who have terrible diagnoses kill themselves, even though one might say they're not actually dying. They could be treated. Should that person qualify? The entering into the mind of somebody who takes their own life is an absolute impossibility, and that's why the whole problem with this bill, I'm afraid. We're trying to create distinctions that are impossible to properly police. It goes to the Honourable Gentleman's point about trying to police private conversations. That's what this bill entails. We are inviting the state to intrude itself into the absolute impossibility of what's going on in people's minds. And back to her point, there is no clear distinction between somebody who would choose an assisted dying through a doctor's prescription and one who would choose to take their own life without assistance. It's not possible to draw that distinction. And in fact, we see so many times how people who might want to kill themselves one month change their mind a month later. So I'm afraid that there's a challenge with the whole bill. Go back to my own
Rachel.
I thank my honourable friend for that intervention, and I would support what he's just said. So I think let me make my point, please. Outside of this context, if I were outside of this place talking about this topic, I will talk about it in a manner that is as sensitive as I possibly can. When we are talking about the legislative changes that are needed to this bill and how it interacts with other legislation, I will use the correct legal terminology, because I think it's really, really important that we do that. Of course.
Dr. Marie Tittle.
I appreciate her raising the need to use accurate legal language. And would she agree with me, therefore, introducing undue influence, which is used regularly in the law of equity, but not in the criminal law, would unhelpfully complicate matters when coercive behaviour is defined in Section 76 of the Serious Crime Act, or rather it provides for an offence of controlling or coercive behaviour in that context. So we have 10 years of case law. The Honourable Lady rightly pointed to the importance of looking at case law and how courts have dealt with this, and the understanding of coercive in the criminal law in terms of offences is well known and well rehearsed, whereas the use of undue influence in this context, the criminal law context of offences, which is what we are dealing with in clause 26 of the bill, does not.
Rebecca Paul.
I thank the Honourable Lady for that point, but I don't think we are talking about criminal here. We're not. This isn't relevant to Section 24. This is relevant to. It's relevant to eligibility. So we are simply just saying with this amendment that if a clinician thinks someone has been unduly influenced, that they wouldn't be eligible. So I think you're sort of crossing over with the encouragement point, which we're talking about, but these are separate points. I'm going to give way to the Honourable Member here if he still wishes to make this intervention, because I'm aware he was being waiting.
Daniel Francis.
Thank you, Madam Chair. I just want to bring us back to the Right Honourable Member for North West Hampshire points. Now, the way I understand it, I may have misread this wrongly, but under the current law, and under the law as it would stand if this legislation was introduced, it would still remain an offence to encourage somebody to commit suicide with a 12-month diagnosis, or somebody who had motor neuron disease, or someone who had Parkinson's disease, who may still be your loved one. So what I don't understand on that counter-argument is this argument about not having the word encouraged in here, because it would remain a criminal offence, unless I'm mistaken, for somebody with more than 6 months diagnosis to encourage them to take this decision.
Rebecca Paul.
I thank the Honourable Member for that intervention. Exactly right. So as I mentioned before, it is not me personally bringing in this concept of encouragement. It is already in the law currently. It is already an offence, and therefore I am putting forward the very logical amendment in order to deal with that in this bill. If we don't, we haven't circled the wagons. It just doesn't make sense. Of course I will.
Dr. Neil Shastra-Hurst.
I'm grateful to the Honourable Lady giving way, and I have no doubt she brings this amendment with very good intentions due to very genuine concerns about the safeguards. But we've talked a lot about coercion. In fact, Clause 1, subsection 2b sets out that the decision has been made by a person that they wish to end their life voluntarily and has not been coerced or pressured by any other person in making it. And pressured is an important word, because we look at the case law, and we've got the comments of Lord Nichols in the case of the Royal Bank of Scotland and Ettridge number 2 from 2002, who looked at the concept of undue influence and looked at two components of it. There are those acts of improper pressure or coercion, such as unlawful threats, and that fits with the coercion elements of the bill as drafted. But there's also a relationship where one has acquired over another a measure of influence or ascendancy of which the ascendant person takes unfair advantage, without any specific acts of coercion. I wonder if she could set out why she thinks unduly influence would add something beyond what pressure does already in the bill.
Rebecca Paul.
I thank my honourable friend for that intervention, and I know he is very knowledgeable on these things and is someone that is very well qualified in terms of the legal side, so I very much value his contributions on this. I think really the reason that I would like to include unduly influence here is because it deals with those more subtle forms of coercion. So, you know, arguably it could be included in coerced or pressured, but by including it on the face of the bill, it becomes more explicit that a clinician has to be looking for that. In the absence of it, clinicians won't be required to look for those more subtle forms. So, and this is something that is included in other jurisdictions' assisted dying laws. So I think, you know, we have the opportunity here to learn and benefit from other jurisdictions that have already implemented. And as we saw, we had various witnesses give us very useful evidence during the sessions. And I think it's California where they include undue influence. So I think, you know, we should recognise that, you know, there is value in including that here. It is a well-established legal term that is used in, you know, a myriad of situations here. So I think it is relevant that we would include it in this. I will give way first.
Now, Sean.
Honourable Lady.
I thank the honourable member for giving way. I just wish, if I may, just take her back to the point of the clause 24 in particular, and coming back to the issue of suicide and the terminology, and perhaps the minister could add, respond as well. I'm not sure how that would work in a PMB, but one of the things that we're doing in clause 24 is to decriminalise suicide. Now, decriminalise encouraging suicide.
Assistance.
And that is my understanding. So can we have some clarity? Are we trying to decriminalise encouraging suicide? Because that's what clause 24 says. So in that case, it would be absolutely right to be talking about the word encouragement.
I thank the Honourable Lady for that intervention. So, so section 24 is decriminalising assistance to commit suicide in order that assisted dying becomes lawful. It doesn't specifically decriminalise encouragement, which means the Suicide Act 1961 still applies if someone were to encourage someone to commit suicide, and therefore it would be a crime and, you know, would have a sentence associated with it. But I think the Honourable Lady makes a really good point. I think it would be of great value at the relevant time to hear from the Minister in terms of the legal point I'm making. I hope everything I've been saying is coherent and sound, but it would be very useful to hear from the Minister at the relevant time on that point.
Thank you.
Kim Ledbetter.
And she's doing an amazing job and taking lots of interventions. I think I'm very open-minded, as I've always said, to whatever we need to do to make the bill more robust. But my concern, and I'm not a lawyer like you, like the Honourable Lady, we have lawyers in the room, fortunately, who can provide guidance and assistance in that regard. But what I have been, what has been made clear to me is the law needs clarity. And the Honourable Lady's already mentioned a couple of times that this could be described as a lower level of coercion, or it could be argued that there's a lack of clarity there. And I think the sentiment is absolutely right, and I really support that. But we need law to be clear. And I think if legal colleagues are assuring us that the concept of undue influence would be covered under coercion, which I'm kind of hearing that, then I think it would be covered. And I think that point about the law being clear is really important. And does she agree with that?
Rebecca Paul.
I thank the Honourable Lady for that intervention, and I know that the Honourable Lady wholeheartedly is seeking to make sure that the safeguards are as good as they can be on this bill, and so I very much appreciate her sort of recognising the positive intent I have here with bringing these amendments. I think it would be very useful to understand whether those who are legally qualified believe undue influence is already covered by coercion. That is a point. I am not qualified to give a view on that. If that were the case, that would provide some reassurance, and that could then maybe be included in some guidance. However, I would want to see a legal opinion on that, I think. And in the absence of such a legal opinion, I would suggest putting it on the face of the bill is the safest and the right thing to do at this point in time. Because I think the reality of the matter will be that we will be voting, I suspect, on this shortly before we can get a legal opinion. And given we are talking about safety here, I would rather be belt and braces and include undue influence on the face of the bill. I will, of course.
Lewis Atkinson.
Thank you for giving way. Can I just clarify? So, as my honourable friend from Penistone and Stockbridge is saying, I understand that undue influence is an existing meaning, but only in equity law. And she herself mentioned when wills, for example, were being challenged in probate. There, as I understand it, the burden of proof rests so fully on the person doing the challenging, someone challenging a will, not in an active test that someone has not been unduly influenced. So if she is to use that as an existing legal concept, would she favour then reversing the presumption on the burden of evidence? And in addition, I think there is a distinction between actual undue influence and presumed undue influence in the case law, and I wonder which of those she thinks we should be using in considering this amendment.
Rebecca Paul.
I thank the honourable member for that intervention. So I think the point you make on probate is right. It is commonly used there, but it's not just used in that situation. My understanding is that when it comes to making decisions in, by clinicians with regard to withdrawing, life-sustaining treatment, that undue influence is one of the considerations. I will.
Danny Kruger.
Just to amplify her point, that's absolutely right. In the Ray T case, the Court of Appeal judged that undue influence should be taken into account in medical decisions. So I think that's an existing principle in law, and it feels totally appropriate to bring it in here, seeing as we've discussed, the principle already exists that it's wrong to encourage suicide, and that it's possible to have undue influence without coercion or pressure being present. So I don't think, to the Honourable Lady's point, that those terms are adequate to include undue influence. The undue influence can exist even where there's no evidence of coercion.
Rebecca Paul.
I thank my honourable friend for that intervention, and so I think the point that I would make is that given already, if someone were, and we talked about this a lot yesterday, so I know it's an example that resonates for many of you, if someone is making a decision, a treatment is being withdrawn, life support is being turned off, then undue influence is one of the things they consider. So surely, when we're considering assisted death, surely, in order to be consistent, you would apply undue influence as well to that, rather than having a lower level. I mean, why would we have a lower level, a lower threshold for assisted dying compared to withdrawal of treatment?
Would the Honourable Lady give way?
I will give way.
Sarah, on
I thank the Honourable Lady for giving way. I'm just reflecting on what the member for Sunderland Central and the member for Penistone and Stockbridge have said about how existing concepts in law, and this is how they've always been used, and it's quite reminiscent of the conversation we were having yesterday about the Mental Capacity Act, and that being an established concept in law, and this is the way that it's always applied. And I do wonder if the Honourable Lady would agree with me that precedent and established usage are extremely important, but this is quite a novel piece of legislation, and it is really incumbent upon us as a committee to think about, do we need to approach this legislation in a different way compared to other pieces of legislation that have gone before, and whether just because something has always been used in a particular way, it is still appropriate for it to be used in this way for this legislation as a general principle.
Rebecca Paul.
I thank the Honourable Member for that intervention, and I completely agree. And I think if we don't incorporate undue influence, we are at a lower threshold compared to withdrawal of life-sustaining treatment. So that doesn't, to me, feel like the right position. But equally, to the Honourable Member's point, this is a novel bit of legislation, and I actually think we need to increase the safeguards further, and obviously there will be numerous amendments that we will be talking about as we go through, which are all aiming to just increase that threshold to a better level. And obviously it's always very hard, you know, it's how long is a piece of string. It's very difficult to know exactly where the threshold could be set. Different people are going to have different views on that. But right now, I think in this bill, my personal view is the threshold is too low, because, you know, we need to increase it by making some of these amendments. I mean, at the moment, none of these amendments that have been put forward have been accepted. And I really, really hope that we are going to improve the safeguards in this bill over the course of this committee. I will, of course.
Kim Ledbetter.
Probably to be my final point on this subject, but I think there is consensus in the room that no one is saying undue influence is acceptable. I think the question is where it sits within the bill in terms of definitions. I think that's and I think that's where I would appreciate, along with the Honourable Lady, advice from legal experts and indeed the Minister around, are we confident that with the concept of coercion we are including undue influence? Would she agree with me that that clarity would be quite helpful?
Rebecca Paul.
I thank the Honourable Member for that, and I absolutely agree that clarity would be very, very useful. Like the Honourable Lady, my intention is just to make sure it is captured somewhere. I'm less picky about where. Obviously, we put forward amendments and we have to put it in specific bits of legislation, and it's very difficult when we don't know what other amendments are coming through in course. But as long as it gets covered somewhere in the bill, I think that would be an improvement to the bill, and I hope it's something that everyone would really welcome, because I think everyone does recognise the issue here. I'm not hearing that, you know, people are opposed to this. They do recognise that we have these more subtle forms of coercion. So I think if we can work together to work out the best place for it to go in the bill, then, you know, very open to that. Okay.
I was going to say, would she give way?
I will.
And with,
Sarah Sackman.
Thank you. And with your permission, it might help if I do, with the usual premise that, of course, the government is neutral, but offer the government's position in respect to what the Honourable Lady's been discussing. I think it's important to point out that the terms coercion and coercive behaviour and pressure that are used on the face of a bill appear in existing criminal law and criminal offences without statute definition. In other words, they're given their ordinary meaning and they operate effectively in that manner. The criminal law, and when we come in due course to clause 26, and she's absolutely right, of course, that clause 26 is a separate matter, but of course it will be important to review the bill as a whole and understand the interaction between the different provisions in clause 1 as we trace it through to the criminal offences. It's the government's view that the sort of manipulative behaviour, undue influence, the terms that she is using would come within the normal meaning as commonly understood in case law by the judiciary under the terms pressure and coercion. And in terms of the integrity of the statute book, there is a concern that we run the risk by adding additional terms that we create confusion, because of course when it comes to the interpretation of those provisions,
Judges will be looking to understand and ascertain, well, what did Parliament mean by undue influence that isn't covered currently by coercion? And given that those terms are commonly broadly interpreted, it's the government's view that the sorts of behaviours that she's describing, undue influence, would be covered by the terms used on the face of the bill. And that simplicity and dealing with the existing body of law that we have that interprets those provisions widely to ensure consistent application of the law in this context, as in other contexts where coercion arises, it would be important from the government's point of view to retain the current wording on the face of the bill.
Rebecca Paul.
I thank the Minister for that intervention. It's very, very helpful to understand the position. And I hope the Honourable Member is right on that front if this amendment doesn't go through. But the one thing I have learnt in my time is that you can go to different judges and they'll have a different view on these things. So for me personally, I would much prefer to see this on the face of the bill. I think that absolutely ensures that that protection is in place, because as we all do know, in the courts, decisions sometimes can go a different way to what you expect. I will give way.
I thank the Honourable Member for giving way, and I have a concern with what the Minister has just talked about, because in the absence of a bill that is, as one psychiatrist put it, very novel, not tested, the MCA that hasn't been tested, and now we have the government saying that this would work without consultation, without any impact assessment, and I'm struggling to understand why we'd come to that idea. Does she share my concern that this doesn't feel right?
Rebecca Paul.
I thank the Honourable Lady for that intervention, and it's reassuring that, to hear that I'm not the only one worried about this, so thank you for that. Okay.
Will she give way?
I will give way.
I just wonder whether she's reference to what the Minister just said, because I understood the Minister to say that the judge needs clarity when they come to adjudication of the case. We've heard through the media, not yet an amendment tabled, that there's not going to be a judge overseeing this process. So does she share my concern that we're setting up a legal system that will not have a proper legal oversight over the measures that are being proposed?
I thank my honourable friend for that intervention, and I think that goes to the heart of the case and to the point I was making earlier, which is it's extremely difficult when we have a moving feast with this bill. So we are trying to put forward amendments in the context of the bill as currently drafted, but obviously if substantial changes come through, that impacts some of what we're doing earlier on. So I think you make a very, very good point. Yes, I will give way.
I think we're looking at different amendments as we know as the bill progresses, but in terms of a judge being involved in criminal offences, there would always be a judge involved in criminal offences, which is what we're talking about now.
Rebecca.
I thank the Honourable Member for sharing her view on that.
Will she give way?
I will give way.
I'm very, this is a very helpful conversation. Thank you, Chair. I'm really grateful to her for the way she's allowing all these interventions. That's absolutely right. There's going to be there will be a judge in the event of a criminal offence. What we're trying to do is ensure that we don't get to that point by insisting that at the early stages of the process, when the doctor is making their assessment, and indeed if the judge is making their assessment, if they're still at that judicial stage, we hope they will be, they are required to ensure that there has not been undue influence. So what the real importance is that at that early stage they are asked to check not just whether there's been coercion. I hear what the Minister says, that she hopes that the concept of undue influence would be somehow incorporated in the definition of coercion or pressure. But actually what we need to ensure is that test is applied at the very early stage. The first people who are discussing with the patient ensure that there's been no undue influence, which, by the way, is about much more than just outright coercion. It's about the imbalance of power in the relational dynamic that exists within families, which, as we all know, can be very, very complicated. So that's the necessity of the amendment.
Rebecca Paul.
I thank my honourable friend for that intervention, and I completely agree with what the honourable member is saying, and as always, he makes the point very powerfully. I will give way.
I thank the member for giving way. Would she also share my concern, given that, and in normal parliamentary business, from my understanding, is that in in the chamber, in the House, when the government announces any changes to the law, if they go to the press first, it usually gets the rebuke from Mr. Speaker. In this case, I appreciate it is a private member's bill, but the truth is that we have a Guardian piece from yesterday which outlines that there will now, we're scrapping the High Court judge and we're going to have a panel, and there's an amendment being tabled to that, or the honourable member, and I'm happy for her to clarify, that the system is going to change. So in light of that, what she's proposing, these amendments, in terms of undue influence, coercion, once we've debated them, we can't come back to these because of the nature of the way a private member's bill is actually discussing this. So does she share my concern that it comes back to what we said yesterday, the horse has bolted and now we're having to go over things and we might not be able to revisit this. And that's why it's even more important to have these probes and conversations here, to put them on record and to be able to refer them, if nothing else, at third reading, which we'll only have 5 hours for.
Rebecca Paul.
I thank the Honourable Lady for making that point, and I completely agree. And I think one of the mistakes we shouldn't make is assuming certain amendments are going to be accepted. I mean, until there's a division, we don't know what the bill is going to look like, and it is incredibly difficult to be putting forward amendments early on when you don't quite know if other fundamental things are going to change. But that's why it's really important, I think, that we're really thorough and we improve the safeguards as much as we can, clause by clause. What I don't want to do is to get to the end of this, and we haven't accepted any of those improved safeguards, and then the bill is turned on its head at the end when there's a division on something quite fundamental. Because as the Honourable Lady rightly says, we don't get the opportunity to come back and review what the decisions we've made. On the back of that, I will.
Sarah,
I'm grateful to the Honourable Lady for giving way. And further to the point made by the member for Bradford West, is it not a further complication that if a question is put in committee and considered settled, it then can't be revisited at report stage by any other member outside of this committee, and that it may well be the case that amendments accepted further down the line have a fundamentally change the nature of the bill, and then perhaps questions that are considered settled on these early clauses, which perhaps members beyond this committee would then want to revisit, they will be prevented from doing so because the matter has been discussed in committee and considered settled and then can't be revisited at report stage.
But that is the
I thank the Honourable Member for that contribution, and as a new MP, I think there are many here in this room today, I'm still very much learning the process. So actually we've got that to contend with as well, in terms of not quite understanding how the full process works. Now, obviously, in 2 years' time, I think I and many of my other new colleagues would be in a different position and would fully understand all of the interactions and the subtleties of the legislative process. But that is also a challenge I have, and that is why right now I will always just put forward the most robust amendments that I think will safeguard the most vulnerable in our society. I will give way.
Dr. Simon Ofer.
I'd just like to bring this committee back to a certain amount of reality. What we're talking about here is how can we assist clinicians to assess coercion and pressure. And so what I'm thinking is does your amendment, and I like the way we've discussed this in a very sort of, a good way of supporting, trying to make this bill safe, but does your amendment make that any easier for the clinician? And I don't think it does. I think this is very clear in the bill as it is, and I don't think it has got any implications if there are further amendments, because this is a statement of what we're doing, and I think as a clinician I would understand and be able to apply that. Thank you.
The amendment, Rebecca Paul.
I thank the Honourable Member for his intervention, and I think you're absolutely right. It doesn't make it easier for the clinician. My job is not to make it easier for the clinician to determine that someone is eligible for assisted death. It should be a robust, rigorous, well-considered process. I will give way to the...
Liz Savile-Roberts.
The point of the Honourable Lady about the mechanism by which we are making this legislation to be very pertinent. I mean, I have been here for almost 10 years, and again, as somebody from a small party, experiencing how bill committees, if you like, from the outside, is something that I suspect we are all experiencing this time round. I think just to put in that we need a note of humility. On the one hand, we are all of us here trying to make this bill as watertight and a piece of legislation that will work as well as possible. That very much then comes over to the government. I know we are here as a private member's bill because of the nature of the ethical question with this bill. I am very comfortable with that. But nonetheless, there is an immense responsibility in the next stages with the questions that we raise, and perhaps it might be an idea not to push this to a vote, but I'll leave that entirely to because that then keeps this matter alive. But there is an immense responsibility on the issues that we can only touch upon here in the government to listen to those and make sure then that they are actually all sewn together.
Rebecca Paul.
I thank the Honourable Lady for that really helpful intervention, and that's exactly the kind of advice that is extremely useful to us new MPs that are undertaking this process. And obviously, you know, I think I'm going to have to make the decision on that in matters of minutes, potentially. So it's very difficult, but I will do my best to make the right decision. Okay, I'm going to continue. I'm nearly done. So I just wanted to reference new clause 5 as well, which seeks to define encouragement for the purposes of the bill and include some exclusions. We've obviously already talked about you know, some of the challenges with exactly what encouragement means, and clearly there is certain acts that we don't want to be captured by this. So the aim of that clause is just to ensure that it's only intentional, targeted and effective encouragement that is covered. But I am very open to working with the government to ensure the drafting reflects the intent. It may well be that some other things go in there to address some of the concerns raised by my honourable friend here, you know, around, you know, support being given by families, because I think clearly no one wants to see that you know, included in this definition. I think we all agree on that point. So, in summary, I hope you will view these amendments on incorporating undue influence and encouragement into Clause 1 favourably to bolster the safeguards in this bill. It is vital that more subtle forms of influence are addressed to protect patients and ensure it is not just the obvious signs of coercion that are looked for. Before I finish, I would also like to welcome the Campbell Amendment 113, which is very much in the same spirit of Amendment 23 and 82 and inserts the word manipulated. I do hope we will be debating it, as it would certainly improve the safeguards in this bill if accepted. Thank you.
Amendment 23 to Clause 1. As on the amendment paper, the question is that the amendment be made. Nasha.
Thank you, Chair, and it's a pleasure to follow the Honourable Lady. Just to put it out there to begin with, in terms of the amendment that we're talking about, the Court of Appeal in the case of RET held that undue influence was relevant to medical decisions, and the court said that the doctors must check for it. That was the name of the case. So undue influence is about power imbalance rather than outright coercion. And when we're talking about, and it brings me nicely on to the points that we did discuss in some detail yesterday. So the Honourable Member talked about if he was having a conversation with his family and he had, you know, a conversation between his wife, his children, etc. Now, I'll give another example. If we have, for example, a woman who has been the victim of domestic violence, and we know this happens, we know 2 women a week are killed, indeed, in this country to this day, and you're subtly encouraged, sweetheart, you've got a diagnosis, and the option is to have this. This is going to, it's, there is a fine line. In fact, the fine line conversation has been used quite often as well. But for me, I'd rather stay on the side of caution on the issue of that fine line conversation when it comes to domestic abuse and coercion and the power imbalance in a relationship. And if we have coming back to that woman or that elderly person whose loved ones have the conversation. Indeed, they have the conversation. It happens every day. If you ask any victim of domestic violence, on average, it takes a woman 40 times to leave an abusive partner. That's a fact. Because we don't even recognise. I know somebody recently who left an abusive partner. It took 3 years of encouragement because she did not recognise what was happening to her was power and control. And it is where there is power juxtaposed with vulnerability, there is potential for abuse. And that happens. It happens every single day. So not just for victims of domestic abuse in terms of younger people, but even when it comes to elderly people, we know, according to Age Concern, we have over 375,000 people who they say are at risk of domestic abuse, older people. So we have this cancer in our society, which is the abuse of people. And that's subtle, very, very subtle power imbalance. And that is where that fine line is crossed. So for me, and the fact that the Court of Appeal has ruled, and the Court of Appeal is already saying that this is, medics have to look out for it, undue influence, then I would argue that the members' amendment actually strengthens the bill, which is what the member, the honourable member, the sponsor for the proposer of the bill, my honourable friend from Spen Valley, I made a mistake yesterday to refer to her old constituency, for Spen Valley, has insisted repeatedly that this needs to be the tightest bill in the world. So how does this not complement her view? How does this not strengthen her view and strengthen this bill to protect victims?
Would the Honourable Lady give way?
Absolutely happy to.
Thank you for.
So, Jan Joseph.
Thank you for giving away. I hear mentioning about domestic violence and vulnerable people. Do we also need to think that there are lots of people who may not have any relatives in hospital beds, in nursing homes, who may get influenced or encouraged by the professionals because of the pressure on the system, the NHS, the hospices and the pressure on the system? Would the professionals also do encourage them to choose this route? And this amendment will strengthen that as well?
Nisha.
I thank the honourable member for his intervention. I'd like to hope that that would never happen. And I have a huge love for the NHS and the people I know who make everyday decisions under such circumstances, particularly with all the, with all the cutbacks we've had in the NHS, especially even more so post-COVID. But there is that risk. I'd like to hope it's a very, very small risk. But when it comes to mental health, and it goes back to the debate, as the member mentioned earlier, similar to the debate around capacity, doesn't it? It's that same conversation of whether something is fit for purpose, and just because it is already in existence doesn't mean it would necessarily suit what we're doing here. Because unfortunately, when it comes to victims of domestic violence, we're on International Women's Day in this House, very eloquently, the member for Yardley, the Minister for Violence Against Women and Girls, reads out a name list of people who have been murdered. And that's 2 a week. And I keep coming back to this because, and I make no apologies for coming back to this, because there was an article only yesterday about women's charities who support victims of domestic abuse, citing their concerns. And this amendment speaks to those concerns. So how can this amendment not support it? And the idea that it would be an element of jeopardy, I'm not convinced it does, given the legal argument that if we were, it would bring an element of... If there are people make decisions with families every day, we sit, we have conversations, and I speak from a position of privilege, as do all of us in this place, quite frankly. We speak from positions of privilege, talking about how we have these conversations with our families. But we know inequalities exist. We know people don't have those privileges. We know society is unequal. We know domestic abuse exists. We know elderly abuse exists. We know mental health issues exist. We know it takes 14 months just for, in my constituency, just for a CAMS referral for a young person. I appreciate we're not talking about young people, but the point is that we have real backlog in NHS in waiting times, in terms of pain medication, in terms of you know, lots of palliative care isn't equal. I've said that before yesterday. So I'm just asking members genuinely, what is it? Which bit of this can't we support? Happy to give way.
Sarah Olney.
She's making a powerful speech, and I just wanted to reference an article she read yesterday about domestic violence in relation to this bill. It may have been the article by Sarah Dighton in the New Statesman that I also read yesterday, and it cited 2 cases where people had been on trial for murder. They pleaded mercy killing, or that they had carried out the killing of their spouse or their partner on the basis that that person was suffering greatly at the end of their life. But in both cases, when the evidence was examined, those particular men were found guilty of murder, because it was very, very clear that that was what had actually happened. And I think, and it had a profound impact on me, because it really demonstrated to me the risk that we're running here, that people will be able to use a piece of legislation like this as, you know, in instances of domestic violence, and that is something we really do have to take very, very seriously and consider the implications of.
I thank the honourable member for her intervention. It's a very powerful one, and she was absolutely right. It was that article, and it does have a profound impact when you read about these stories. There is nobody on this committee. Absolutely, I'm happy to give way.
I thank her for giving way. She's making some really powerful and important points, sadly, about a lot of the ills of society, which we're all dealing with. But would she agree with me that at the moment, let's take an example of a woman who has a terminal illness and is coerced, pressured by a loved one to end their own life. At the moment, we have no idea if that's happened or not, because there is no legal framework around that dreadful situation. And what this bill would do would create a legal framework so the conversations were had with that woman prior to that point, and hopefully that point would never happen. She would speak to 2 doctors, she would speak potentially to a psychiatrist, she'd speak to other experts to make sure that didn't happen. At the moment, there is no legal framework around that. And also what the bill includes is a criminal offence of coercion, where someone could go to prison for 14 years. And at the moment, that just isn't there.
I thank the honourable member, but I really do feel that the point is being missed in terms of, yes, there is no framework, but that they're not. So somebody to get to here, they need to have a terminal illness in the first instance. There isn't any framework. The framework of domestic violence and domestic violence laws exists for everybody. Once they come into this, that doesn't mean. So what I'm trying to say, the idea that there isn't a framework that exists. This law doesn't exist, so there wasn't the frameworks that already exist for women fleeing domestic violence. There's no shortage of attempts to try and get those frameworks right in law across society, which is why we had the Domestic Abuse Act in 2021, which is why we've committed to half violence against women and girls, why the Prime Minister's made it his commitment, his personal commitment, and rightfully so. What I am saying here is if we've already got a test case where a judge is saying that there is an obligation upon medics, and I know the honourable member yesterday referred to this being as a treatment, albeit I disagree, and we had the conversation later. No, sorry, I was talking about the other honourable member, not the minister.
Apologies.
No, it's fine. Sorry, I've lost my thread now. So we already have laws to protect victims of domestic violence, but that doesn't mean that they necessarily access them. In this instance, we're saying that, happy to give way.
So from what I understand, thank you to the honourable member for giving way. From what I understand from the bill sponsor, the argument is we should put these measures in place to protect people from coercion if they've got less than 6 months to live, but we wouldn't put those protections in place for someone that's got 9 or 12 months to live. So does my honourable friend agree that if we were putting those measures in place for someone with 6 months to live who's living within coercion, why are we not doing that for someone with 9 or 12 months to live?
The honourable member, thank you for his intervention. He makes a valid point. What I'm coming back to this point, the adding, if we already know the case has been tested, a court of appeal has ruled that there is an obligation to look at, and the words were specifically to look at undue influence was relevant to medical decisions, and the doctors must look at it. If that's already a ruling, then I'm struggling to understand the resistance to add a word which includes undue influence to a bill that should be, in the proposer's own words, the most safe in the world. And a judge has already ruled on it. We already know we're not going to get to a judge. I'm just struggling to understand that, but I'm happy to give way.
If I may I think essentially, certainly where I'm coming from, is as the Minister pointed out, the concepts that the Honourable Lady is trying to embed within the bill are already covered within what is a settled legal interpretation and a framework which is, over the last 10 years, has become used to dealing with those issues. My nervousness, as I say, is about injecting, and don't forget, families who are going through this will be advised and will examine the legislation quite carefully, injecting yet another level of consideration for them that might mean that conversations are interpreted by them, not necessarily legally, in a way that is not beneficial to the patient. So, for example, and I understand the group she's seeking to protect, and obviously that's what we're all trying to do, but for the majority of people, in circumstances where, for example, darling, I'm thinking about taking an assisted death because of my horrible disease, what would you do? If you were me, what would you do? Right, if I then say, well, painful though it is for me, I'd do exactly the same thing. How do you think families would interpret that? And then the third point I wanted to just make was in response to the Honourable Gentleman's point, which is a strong one. I'm not sure he's exactly right. I think if at 9 months I have a disease which is progressing and somebody says to me, or somebody in my family says to me, when it comes to it, Kit, you absolutely have got to take an assisted death. We really want you to at 9 months. Right? But then when I get into the 6-month period I do, my interpretation of the Act is that would be, and I tell the doctor, and Dr. Texter, my interpretation of that is that would be covered under the bill. So I think what the Minister was trying to establish eloquently was that we have to be careful about the clarity of the legal language and not to make it embroidered in a way that makes interpretation by lay people as well as lawyers more difficult and more complicated, and particularly in a way that skews behaviour, and I'm going to come on to this in the next grouping, in a way that makes what should be healthy and fulsome discussions within families guarded and nervous.
I thank the Honourable Member for his intervention, and I'd respectfully disagree with him that this is a settled position. And I'd also challenge what the Minister has said, and I've put it on record. I struggle with understanding how the government, in this instance, can say it's a settled position, and it does so without having gone to consultation on this particular bill, without having an impact assessment. That doesn't satisfy me. So for me, my role when I agreed to be on this bill committee was come in and scrutinise and help strengthen this legislation. And in doing so, these are the things that I am pointing out, because these do not provide the safeguards which are strong enough for me. Furthermore, coming back to the Court of Appeal, in medical interventions, and this would be a medical intervention, albeit to end somebody's life, this would be an administration of a lethal drug to end somebody's life. And it would be done by medics. And there are medics involved in every stage of this. And if there is case law which is already established that doctors have to look at undue influence in medical decisions, then I come back to the committee, every single person here, and say, why is it, what is it that we are resisting? What is it, when a Court of Appeal has already said so, Why is it in this committee we are having the debate of keeping this out because it makes it complicated, when actually, if we go back to the words of Dr. Jamila Hussain, who gave evidence to this committee in her evidence, and what she said was, she's a clinician, and she absolutely accepts that there are some people who she would really benefit from this law, and she would, as a clinician, wants to get there. Indeed, I spoke to Professor John Wright in a conversation, and he said, "Nah, absolutely, you know, this is where we need to be." However, for these, yeah, I'm happy to give way.
My honourable friend has given way very kindly, and she's making very powerful arguments. I think she's absolutely right to focus on protecting the vulnerable people who this law might apply to, and she touched upon the medics. I also want to mention the role of the state here, and bring it back to the role of the state and what we're talking about. As somebody opposed to capital punishment, I link it into that because what we're talking about is the state giving someone the method by which they can end their own life, or permitting them the method, handing them a pill for them to end their own life. And I'm concerned that if we are not taking these safeguards seriously, as well as not abandoning vulnerable people, we are allowing the state to aid and abet the abuse and misuse of this bill in order to put vulnerable people at risk. Do you share those concerns that I have?
No, sure.
I thank the honourable member, and I do share the concern that if this bill isn't tightened and it's not fit for purpose, then we cannot afford those people to be slipping the net. We can't be. One woman dead is one too many. One older people dead is one too many. And that's the bar we have to set. And coming back to Dr. Jamila and what she said yes, absolutely. And there was not a single committee member or members anybody who is familiar with this debate. It was heartbreaking to listen to members who came in to give their testimonies about how their families died. And those stories stay with you forever, and rightfully so, because that is what we're trying to get to. And for me, that's why, in principle, and I'm absolutely supportive of where we need to get to. What we can't do is get there, and coming back to the word of Dr. Jamila, for people here who absolutely need this legislation, we cannot ignore this big lot of people here who there are vulnerabilities, there are inequalities, and if we do not fix them inequalities first, and we never, let's be honest, as legislators, we know we're not going to fix every ill in society. Otherwise, we wouldn't need a police force, we wouldn't need laws if everybody was behaving in a way which we absolutely shouldn't, supporting each other. But we've got to, what is incumbent upon us as legislators in this place is to try our best. Nobody came to this bill committee thinking this was going to be a walk in the park. Nobody came here, right? We certainly didn't know we were going to get evidence throughout it. There were plenty of challenges that are popping up, let's be honest. But we came here because this is something, and I came new to the subject, because it is of such importance. Sitting through the last 5 hours in the chamber that day and bobbing, and as with another 100 colleagues who didn't get to speak, we made those contributions absolutely on both, on those for opposing the bill, those who had concerns for the bill, those who were clearly not going to support the bill. Everybody was doing it because they feel very, very strongly about it. That is our responsibility, and I come back to the members' amendment, that this amendment, there are many important amendments. This is one of those that we should really consider adding to this bill because it strengthens the bill. It does not dilute it, and it doesn't add another hurdle for us when the Court of Appeal has already got it, where we have said it is the responsibility to look for undue influence. I just do not understand the resistance to that. Thank you very much, Chair, and I will be supporting the members' amendment. Thank you.
Jake Richards.
I'm very grateful, Chair. This debate has been really very interesting, and it's reminded me of my life before being elected as a barrister in court, and often I was junior counsel then, and by the time I stood up, all the best points have been taken, and I feel a bit like that this morning, Chair. I do have some observations, and first, is on what is in the bill currently, because my central submission, Chair, is that the bill does more than enough in this area, and that simplicity is what is required, especially when dealing with very complex and difficult subjects, which coercion is. And there are two sides to this coin of coercion. One is about acts from third parties, family members, society at large, and the other is the individual making this decision. And Clause 1 is very clear that as part of that assessment that the doctors would take, that a judge or a panel or whatever, part of that assessment is that a person has a clear, settled and informed wish to end their own life voluntarily. Now that echoes words precisely from the CPS guidance that is currently in operation as to whether to prosecute. Now that guidance has been in use for some time, and it seems perfectly rational and logical to continue that. And the focus of the assessment should be on the individual and whether they're making this choice freely. And Clause 1 does that and makes that very clear, and I presume purposefully echoes the language from the CPS guidance. It then goes on to say, and has made the decision that they wish to end their own life voluntarily and has not been coerced or pressured by any other person into making it. And that, of course, must be read with Clause 26, which introduces a new offence: a person who, by dishonesty, coercion or pressure, induces another person to make a first or second declaration or not to cancel such a declaration, commits an offence. This carries a sentence of up to 14 years in prison. I don't want to delve into the criminal element too much because we are on Clause 1, but it appears... Yes, of course.
I'd just like to understand the expertise which you're speaking from. Is he a criminal barrister, or was he a criminal barrister? Or...
I'm very happy to share my CV afterwards. I practice as a barrister mainly in family law and court of protection law, but also I did practice criminal law as a very junior barrister back in the day in the magistrates' courts up and down the land. I don't want to delve too much into the criminal aspects of this because we are focused on Clause 1. But just gently, it appears to me that Clause 26 and the criminal offence that's set out there is far stronger than the Suicide Act. And it is because in the Suicide Act it talks of an act of encouragement, which is not included in 26, which talks about inducement, which is a much more holistic and wider concept than that from the Act which was drafted back in the 1960s, or probably in the late 1950s. And in my submission, Chair, that actually brings the law far up to date to what modern concepts of coercion and pressure are. Yes, of course.
Thank you so much. I think the Honourable Member is making really interesting points, and actually it's probably more of a question for the Minister, but sort of looking, I've been very focused on Section 24 in terms of the encouragement piece, but actually when you do look at Section 26, that obviously makes coercion and pressure a criminal offence. And what I've heard today is that you think coercion does include undue influence, and I guess I would say, does it include encouragement? I would seek clarification of is undue influence and encouragement captured in Section 26? When I was making these amendments, I assumed not, I have to say. And if that's the case, how does that interact with the Suicide Act, which already makes encouragement of suicide a criminal offence and probably isn't consistent with this? I haven't checked, would have to have a look. Are we going to have two different... I think maybe, I guess the question I'm asking, I think just needs to be looked at. So I think it's very easy to say, isn't it, that undue influence is included in coercion. Well, it has a knock-on impact, actually, to a lot of other things. So I think we need to be really clear on that point.
Jake Richards.
My answer to the Honourable Member's first question is yes. In my view, the Clause 26 covers unduly influence and encourage, and I can go on to state why. And my reading of the Act is that 24 subsection 3 essentially removes persons who are eligible by all the other criteria for assistance in death under this Act from the Suicide Act. And then it creates a further Act which in my view is stronger in any event. And that is why, and I genuinely mean this respectfully, because I think the Honourable Member's made very good points and in impassioned speech. This argument about encourage from the Suicide Act, it doesn't follow through. And actually what we have here is a much safer and more modern piece of legislation which is reflective of what we all think of when we think of coercion and pressure. Yes.
Rebecca Paul.
Sorry, forgive me, maybe bear with me. I'm seeking to understand this, and the gentleman obviously is very learned in this. My understanding is Section 24 is only taking out the assistance piece, not the encouragement piece. So there is a possibility from what you're saying. I think you've just said, if I'm right, that encouragement actually now falls under Section 26. But encouragement is also captured in the Suicide Act in 1961. That's my non-lawyer interpretation of reading the bill. So I'm not saying that's absolutely right, but I would appreciate if you could maybe either set me right or...
Well, my reading of the Act, and of course we're dealing with Clause 1, but when we get to 24, is that subsection 3 of Clause 24 in the Suicide Act 1961, after Section 2A, brackets, acts capable of encouraging or assisting suicide, insert. And then essentially those provisions... Yes, of course.
Thank you. Thank you.
Julia Campbell.
Thank you. It is a question that I've got on this, because when you've spoken about Section 26, it suddenly brings in new language. And I'm just wondering, and it's a question for the mover of the bill, is that you've introduced, that the words dishonesty has been introduced in Section 26, and perhaps this lengthy conversation that we're having here it's a continuous discussion on coercion and pressure, and having those two words as a catch-all for things which can actually be much more subtle and much more nuanced, which is the point that the amendment is trying to make, and it's the point that I will be making in my amendment too. However, in Section 26, the word dishonesty has been brought in, which brings in another type of coercion and pressure. My question is, could there be a rethinking of this Section 2, where it says, have made the decision they wish to end their own life voluntarily and has not been coerced or pressured. The issue is coerced and pressured is not sufficient to cover the safeguards that we're asking for in the bill. We're asking for something much more nuanced. Coerced and pressured is insufficient for the bill. We're asking for other words to be added in because that is not a catch-all. But in Section 26, suddenly the word dishonesty has appeared. That's the intervention.
Jake Richards.
I did not draft the piece of legislation, but my understanding is that Clause 26, the reason why dishonesty would be put in, and I don't know whether the Minister would want to comment on this, is that when there's a criminal offence, you have to have a mens rea. So the person committing the offence has to be intentionally or reckless to the point of committing the act. As I say, I was only a criminal barrister very briefly, so I'm sure my law tutors are shaking their head at the moment. Yes, of course.
One of the conversations I'd like him to, and that's why I asked him which area, because I wanted to target my intervention. But in the principle of statutory interpretation, it means that mentioning one thing, you are excluding others. So by having coercion and pressure on the face, that excludes undue influence. That's my understanding. The other thing is, I'd like to understand, and I'd like him to comment, because he's gone through it in quite detail, it can be seen. In Section 2A of the Suicide Act, it says that encouragement includes pressure. So how would you respond to that bit?
Well,
Jake Richards.
Again, with respect, I just think the Honourable Member's wrong on this, that it's certainly not an exhaustive list of factors to be taken into account. And the courts, and this is why we have a common law system, the courts will interpret language and legislation in such a way. I forgot the second point, actually. So.
Thank you, Chair. Just building on that, I'm just trying to understand. Again, when it comes to giving, and again, I referred to the Court of Appeal earlier, but even when it comes to giving your organs, right from the age of 12, 13, I think it is, I'll try and find the reference point, but there is the word undue influence is used in that legislation as well. So I'm just thinking, and again it comes back to the crux of the arguments I've already made, is I'd like to understand his thinking as what is it that he's so concerned about not putting the word undue influence from a legal perspective when it's already there.
The issue I have is that if you open the door to all different types of terminology, then it will be never ending. And actually, the law is best served when it's clear and simple and straightforward. And I just make this point because it's a key point. The issue about unduly influence, you've raised this case of Reti, and the Honourable Member has as well. I must admit, I don't know that case, but I believe it's a 1992 case, Court of Appeal, about refusal of treatment, so 33 years old. The law has moved on, and as the Minister said when she intervened earlier, the terminology of coercion and pressure is much more modern and is used in legislation that has been drafted in the last decade, rather than the Suicide Act in the 1950s and the Court of Appeal case in the early 1990s. And I just briefly last night went back to my law books. I sound like I'm really missing my old job. Looked into where coercion is used across different jurisdictions and areas. And this is what I read. Coercion is a phenomenon the courts have experience of handling. Generally, coercion as a concept in our law involves applying pressure, whether physical, psychological, or moral, to force someone to act against their free will or better judgment. This pressure can manifest in various forms, such as threats of intimidation, undue influence, and is recognised across criminal, family, consumer and contract law. It's used in forced marriage legislation, it's used in criminal legislation, it's used in case law have made it very clear that coercion is used interchangeably with duress, defined as a constraint on a person's choice. I do feel like we're dancing on the head of a pin, and that actually the law has been drafted by one of the most senior parliamentary draftspeople. We've had the government minister confirming that the Justice Department deems this to be a sensible course of action if this legislation is to proceed.
The Honourable Member give way?
Yes, of course.
Does he agree with me as
Dr. Mary Tidwell.
Oh, sorry. Does he agree with me, as Max Hill did in oral evidence, that it would be helpful to have definitions of the three concepts in clause 26? Whilst we are discussing an earlier clause in the bill, it is important to thread the needle with this statute and ensure that we are looking ahead, as you rightly pointed out.
That sounds very sensible. I think that's her amendment that she's talking to. Yes, sounds very sensible. But ultimately, yes, of course.
Thank you. I'm so glad the Honourable Member has spoken, because I think this is a really important conversation, and I appreciate we're probably going a little bit ahead of ourselves, and so I'm just going to be really quick before the Chair tells me off. But so Section 2A of the Suicide Act, when it talks about encouragement, it actually includes pressure, and this is why it's so useful to have this conversation, because that could possibly mean that encouragement is captured in Section 26. And so I think there is some work to be done. I still stand by the amendments. I think it's really important we still have them on the face of the bill, but I think when we get to the relevant point of this bill committee, we need to think about the interactions of Section 24, Section 26 and the Suicide Act, and I'm sure the ministers will want to look at that, but I think we may need to be very clear what's included in what, and it may require some things on the face of the bill so that there's no ambiguity. Would the Honourable Member?
Yes, I agree. And as I say, I think these are perfectly reasonable amendments and sensible to raise them, and it's good that we've had this conversation. And I've looked into it carefully, and I take it seriously. I feel like the circle is, the square is squared, or the circle does go all the way round, to mix my metaphors. But that doesn't mean that we shouldn't look into it further as we get to those clauses later in the bill. Yes, of course. Sorry,
I'm very worried. Thank you. I'm very worried about the constant suggestion that we look at these issues later. I mean, the fact we don't know what the bill is going to look like later. We don't know what we don't know what amendments are going to be tabled. We don't know what will be agreed. It is always possible to revisit amendments that have been passed in the earlier stages, if it comes to pass that subsequent amendments make them otiose. The point is we should not pass this opportunity to strengthen the bill if we can. And just to the point that the Honourable Gentleman was discussing with my Honourable friend, the point of the Suicide Act explicitly referring to pressure being, as it were, a subset of encouragement. The term of the Suicide Act specifies that encouragement is the general term, is the catch-all term, that includes pressure. I think he's suggesting, and Honourable Members have suggested, that it's the other way around, that coercion or pressure somehow includes encouragement. Surely encouragement is the broader term. It exists in the current law on suicide. What is the problem with using that term in addition to coercion and encouragement, consistent with existing law, because it's a broader and more sufficient term.
Jake Richards.
Well, on the first point, in fairness, the Honourable Member was talking about a clause which we are going to be considering, the link between two different criminal offences, the 1961 Act and Clause 26 in this proposed bill. On the second point, simply, this bill is, to coin a political phrase, needs to be fit for the future. And the language used in legislation over the last decade when we're considering coercion, and I use it automatically because that is the language we use now, is much more appropriate than encouragement, which is slightly archaic, to be honest. And perhaps we need to look at the Suicide Act as well. Not in this parliamentary term. That's the second term. Chair, thank you. I don't have any further things to add.
Juliet Campbell.
Thank you, Chair. I'll be speaking to 113 all the way to 121. This amendment requires the coordinating doctor, whether or not, this amendment reflects amendments 113 to 121, which requires steps to be taken to establish that a person seeking assistance has not been manipulated by another person. The amendment requires the coordinating doctor to ascertain whether, in their opinion, the person has been manipulated. This amendment accounts for additional ways that a person can be influenced into choosing an assisted death by another person. Pressure and coercion may leave an individual feeling they have no choice but to take this path. However, manipulation can make a person think that they made the choice themselves. Coercion is an overt and a clear means of controlling someone, whereas manipulation is hidden, it's psychological, and it is a deceptive means of control. I looked at the Oxford Dictionary definition of manipulation, and it says the action or an act of managing or directing a person, especially in a skillful manner, that exercises subtle, underhand, or devious influence or control over a person, interference or tampering. It's controlling someone or something to your own advantage, often unfairly or dishonestly. Although there's not much regulation of manipulation in the law, the argument increasingly is that it really should be regulated. In Eric Poisson's paper, The Law, Economics and Psychology of Manipulation, he argues that manipulation has always been regarded as wrongful, an indirect form of fraud by common law courts and government regulators. Cass Sustain argues that in his paper, 50 Shades of Manipulation, that despite the fact that manipulation is rarely policed in law, the argument is, for legal responses, manipulation is strong. Manipulation is a term we have in law, and it is mainly used in relation to physical crime, but it also can be used in relation to genetic science. I would argue that manipulation should be and could be included in this bill.
Dr. Simon Ofer.
Well, give way. I know you've sat down already. Can I just say, look, I think we're all in this together. We all want the safest bill possible. And so I would say that we should defer to the legal side to form a language which is safest. And I am not a specialist on this legal subject, but we all want the same thing here. And we're arguing about words which perhaps we need to just take advice on to make the safest possible bill. Thank you.
Sean.
Thank you. Just following on from the Honourable Member's intervention, yes, we are here to, I just wanted to respond, we are here to make this bill the safest possible, but this is a new thing, so this is for me, it is, I have to make a decision when this comes back to the House to either support a new bill which is of such huge magnitude to our communities, for our whole country, and this is the process that we're going through. This is the only process that we're having which is available to us, and words matter. The idea of manipulation, that concept of manipulation, as the Honourable Member has set out, and I do support her amendment, is very, very important. And again, I come back to the issue of abuse and women in particular. You know, manipulation. I've never heard the term 50 shades of manipulation. That's an interesting one. But seriously, this happens every day across society. So I would say, I would encourage people to actually, yes, talk about these words. And we as parliamentarians benefit from that. We're better people from understanding other experiences, because there are different people who bring different experiences to this conversation. I've certainly learned a lot, and it strengthens the House in itself when we speak from positions where we've debated. That is the whole purpose of us being here. So I wouldn't be concerned, and I hope she shares my view about talking about adding language, because that's the whole point of us being here in the first place.
Juliet Camp.
Thank you. I'm replying really to your response, and I understand that the writers of the bill and the movers of the bill want it to be as simple as possible. So the thought is, if we make it as simple as possible, that there's less room for confusion and misinterpretation. But there are times when we can make things so simple that we allow far too much interpretation. Words like what my honourable member over there said this morning, and what she wanted to be put into this bill, they are really important. Manipulation is really important. Coercion and pressure are not measures of every type of controlling behaviour that happens to individuals.
Would she give way?
Kim Ledbetter.
I'm very supportive of the sentiment behind the amendment, and I think she's making some really good points. Again, the question is about language and simplicity in terms of what goes on the face of the bill. I'm just looking at the CPS guidelines around coercion and coercive control, and it does refer to such situations as being highly manipulative, such as love bombing, where the suspect will intermittently do what appears to be loving acts, seeking to present these as interrupting or negating the course of conduct. You know, so there is language in there around manipulation. I hope that maybe provides some reassurance that within the broader concepts of coercion and coercive control, manipulation is certainly seeming to be part of that in the eyes of the law.
Juliet Camp.
Thank you. I thank you very much, and thank you for looking that up so swiftly. I still do think that those additional words on the face of the bill need to be included. Coercion and pressure are used as catch-all. It doesn't allow people who are using the bill in their everyday life, that is doctors, clinicians, nurses, social workers, to understand that it's a catch-all for manipulation. It doesn't allow them to understand that.
Now, Sean.
I thank the Honourable Member for being so generous of her time and giving way. Just to come back to the issue of the CPS using it in terminology, does she agree with me that in an ideal situation the bill would be so safe as the proposer has proposed, that we wouldn't get to a place, the idea is that we wouldn't get to a place where we'd be looking at the CPS definition, that actually we'd be making that so tight that nobody would be prosecuted for coercion, for coercing somebody into taking the option of assisted death if this bill became law?
Juliet Camp.
Thank you very much, and thank you for your contribution and your intervention. I absolutely agree that what we don't want is people not understanding what it is that this bill is allowing them to do or not to do, what they were to intervene in. You know, we spoke earlier on about making it easier for professionals, so they're making this bill as simple enough so that professionals understand it and know how to deal with particular instances. The bill is not here to make life easy for professionals. The bill is here to ensure that anyone who is vulnerable, anyone who is 6 months, whatever, for the reasons that the bill is in place, that they are protected. The safeguards that we've spoken about, and I think, you know, generally throughout all the debates, safeguarding and making safeguarding as tight as possible so that people are protected has been a continuous thing throughout all of the debates and all the conversations that we've had. And these additional words are not too much to ask, I believe, to ensure that we are as tight as possible in protecting those people who need our protection every single day.
Danny Kruger.
Thank you very much indeed, Madam Chair. Can I say what a pleasure it is to follow the Honourable Lady and how much I agree with what she's been saying and the purpose of her amendments, which I'll be supporting if we get the chance, as I will the amendments in the name of my honourable friends. The general point to make very quickly, and not to repeat myself from yesterday, is that we make decisions in a context. We make decisions influenced directly by the people around us. And I just want to highlight the very powerful phrase used by my honourable friend earlier. She talked about how love can shroud decision-making. And the influence and pressure that can be applied to us can be shrouded in love. There's a phrase also used by, I think, Professor House, who gave evidence to us, talked about the enmeshment of people's decision-making with the influence that we experience from our loved ones and from people around us. So the fact is, and as honourable members have made this point, power dynamics in families are complicated, and where there is an imbalance of power, there is risk. And I think we need to just acknowledge that. And in fact, the bill implicitly does acknowledge it through the safeguards that it attempts to create. I just don't think they're strong enough. And I know that my right honourable friend is concerned that by strengthening the bill in this way will, as it were, create an opposite risk, which is that a family member who was behaving perfectly properly could somehow be dragged into a prosecution, or indeed that the application would be denied on the basis of a perfectly reasonable conversation that had happened between loved ones. Talks about someone, you know, my darling, do you think I should do this? It's a lovely picture in this conversation. This sweet exchange between a loving couple. Saying to somebody that you agree with the decision that they've made and that you would support it or are content with it or that you understand it is not the same as undue influence. It's not the same as even encouraging. It's similar to the debate we'll be having in due course about the role of the doctor making the overt suggestion of an assisted death rather than consenting to the suggestion that has been made by the patient. Happy to.
Okay,
I understand he's asserting that they are different, but obviously those assertions would be tested in court. But if a person was to appear in front of the coordinating doctor and say, well, doctor, I want an assisted death and my husband thinks I should do it, right? Is that interpreted as encouragement? Is that support? I mean, in the current legal framework, that would be interpretable and inquirable. But I just, as I said to you, I'm nervous not necessarily that families would be dragged into some kind of legal conflict, but they would seek not to get there at all, because the insertion of these words would make them so nervous about the conversation that they would become guarded. It will become clear, as we know from other jurisdictions, that people will understand over time this process, and, as I will refer to in the next grouping, they will start to understand what they shouldn't say if we put into the bill that there are things that will be, play negatively if they are revealed to the authorities that are looking. And so my concern is that unless we keep it simple and clear and leave the space for families and medics to have free and frank and open conversations that are covering, from the medical point of view, the full range of options, obviously, then we start to restrict and police the conversation, therefore make it that much more difficult.
Well, it's certainly an issue throughout the bill, the risk of gaming, of patients playing the game and doctors seeking out words and not words and so on. I recognise that. That is a general problem with the bill. It is not just a free-for-all, which thankfully it's not. But to the point, the scenario that he suggests, my concern is exactly that. If the patient says that their spouse has agrees with them or encourages them, then that is something that should be a red flag. Under the current bill, it's not clear that it would be. There's no obligation on the doctor to record or to push back that there has been undue influence, because at the moment they're only looking for evidence of coercion, which, as I'll get on to speaking, is too narrow a bar to use. So I would like the doctor to, if he hears those words, to start asking questions and to push back and to satisfy him or herself that in fact there hasn't been no overt encouragement or undue influence. That is indeed the point of what we're trying to do. Happy to give way.
I thank the honourable member for giving way, and I'm just coming back to the point earlier, and again, I want to make these points simply because I think it's really important that we get them on the record. The member earlier talked about undue influence and encouragement being perhaps an archaic point. Would the honourable member agree with me that even just last year, the Digital Marketing Competition and Consumers Act, that cited undue influence. The Anatomy Act has cited undue influence. And it again speaks to these. Do these share my concern that there are acts here that are being put forward in this Parliament in the last few years that have used this terminology? And again, the resistance, share my concerns about the resistance of having just these words added to this bill.
I'm very grateful to her, and she's absolutely right. Of course, undue influence does exist in law, and indeed, very recently, I recognise the honourable gentleman is not impressed by laws that are more than 10 years old. I hope he might be satisfied with the law passed last year, sufficiently up to date and modern for him to regard it as morally valid. So she's absolutely right. This is an existing term. We should apply it in this case. Happy to give way.
Just on that point, and in response to my honourable friend's comment, I don't think, but I stand corrected by the honourable member if this isn't the case, I don't think he said that undue influence was an archaic term. I think it was the word encouragement. Yeah.
Danny.
Yes, I mean, if we're going to rule out the word encouraged on the basis of sort of archaism, I don't know what we're going to do with the language. It's a perfectly acceptable term, and I think actually, seeing as we are still governed by the Suicide Act, which this Act pays reference to, is in fact framed in the context of, I think it is appropriate, as I said earlier, to remember that the Suicide Act specifically prohibits encouragement, and it includes pressure within that concept. And the two terms coexist in the same clause of the Suicide Act. So the idea that we can't have more than one word, and that's somehow confusing, I think is wrong. Just a point made by the Honourable Lady, the move of the bill, when she suggested that there was... Yeah, happy to
I just thought, in light of the point you were making, this is an interesting fact you might enjoy. So encourage was added to the Suicide Act by the last Labour government in 2009. It actually replaced aiding and abetting, so it's actually not that archaic.
Oh, my goodness. 2009 might be dismissed of history to the honourable gentleman, but it was the last Labour government, so maybe it's okay. That's very good to know. Thank you. I'm grateful to the honourable lady. Right, so just to the move of the bill's point that and it's a point that's quite often made in defence of this bill, that currently there is no framework to spot coercion, and therefore that this bill sort of adds greater protections for people. I mean, the fact is there is no law currently allowing assisted dying, as the honourable lady said. So there is no framework necessary to prohibit encouragement or any sort of inducement to an assisted death, because the opportunity doesn't exist. So what we're actually doing with this bill, would be doing if we passed it, is, I'm afraid to say, and I think that everyone must acknowledge, we would potentially be opening up a new avenue for abuse, which it is necessary in the bill to close off. And that's absolutely right and appropriate. The answer to the problem of existing coercion and abuse that no doubt does go on and tragically common is not to legalise assisted suicide and to put a regulatory framework around it with, I'm afraid to say, quite limited protections against the sort of coercion and influence that we are talking about. The problem is to deal with that terrible, as the Honourable Lady said, the cancer of abuse and coercion that exists in our society, and that should be our social mission if we are concerned about undue pressure in families. But if we are going to do assisted, I will let the Honourable Lady in a moment, if we are going to do an assisted dying law, surely let's make it as strong as possible, because, as I say, we are potentially opening up a new avenue for abuse within families. Happy to give way.
I mean, for me, there are a number of reasons why the law needs to change, and we'll talk about some of those as proceedings continue through the committee, and that is about autonomy, it's about dignity, it's about personal choice, it's about bodily autonomy. But in terms of the issue that we're trying to solve in this particular regard, we've heard from families who have faced police investigations as a result of a loved one taking their own life. So not only are they dealing with the trauma and the grief and the loss of their bereavement, they then face, and it often is months and months of police investigation. We heard from, I think it was Pat Malone in the oral evidence sessions, who had that when his brother took his own life. So surely the Honourable Member would have to acknowledge that that is a problem. It isn't the only problem, and it isn't the only reason for doing this legislation, but he has to acknowledge that is something that, as legislators, we've got a duty to correct.
Danny Kruger.
Well, a couple of points. I mean, firstly, I'm sure she'd acknowledge that there will still be those investigations because not everybody who commits suicide will be caught under this Act. I mean, not everybody who's terminally ill and wants to take their life with the assistance of their loved ones will be caught. So I'm sure she acknowledges it is still appropriate. In fact, I think the bill strengthens safeguards against unassisted or rather assisted suicide outside the law. Those will still continue. And I'm afraid I regard it as absolutely appropriate and necessary that we do have a law against assisted suicide for all the reasons that we've been discussing. She's right that it's appropriate for Parliament or the authorities in general to ensure that cases such as we've discussed and such as that was powerfully testified to us are handled sensitively. And I think that in an overwhelming number of cases, those cases are handled well and sensitively by the police. But it might be that we need to improve the guidance around prosecution. I think that's an important question for us. I mean, I certainly don't want to see the families of people who have taken their own lives harassed and chased through the courts. I think we'd all acknowledge that, and we no doubt there will always be an evolution of the guidance for the CPS and for the police in that respect. Happy to give way.
Would the honourable member agree, and perhaps he recalls when we did hear from the former head of the CPS, when I put it to him during the evidence sessions, whether this bill would address those concerns of those prosecutions. And I absolutely agree with my honourable friend, the lead sponsor of the bill, in terms of we do want to address that. But this bill isn't the route to address those issues unless it did fall into the 6-month bracket.
Danny Coon.
I think that's right. I think using and claiming that this bill is somehow a response to the problems of abuse in families and of coercion and pressure to end life, I'm afraid I don't accept. And as we know, tragically, in jurisdictions which do have this assisted dying law, numbers of unassisted suicide, of suicides that happen outside the law, go up because no law can catch all people who might want to take their own lives. Thankfully, there's no blanket support for any assisted suicide. They all have some restrictions. But more significantly, the fact that the state is saying that some people's lives are not worth living, that it's an acceptable choice for people to end their own life, which is not what the current law says. We've legalised suicide. We have not actually endorsed suicide. If we were passed a law that endorsed the choice of some people to take their own lives, we are sending a signal that we agree that some people's lives are not worth living. And the consequence of that, I'm just going to make this my point, the social consequence of that is clear in the evidence of other jurisdictions, which is that suicide in the general population goes up in consequence of an assisted dying law. Happy to hear from the Honourable Lady.
Kevin Ledbetter.
Just on that point, I think what the evidence doesn't show clearly is that there's a direct relationship between those two things. I think there are other factors, and there's no way of knowing those other factors. But in terms of the concept of ending one's own life, and giving people the choice under the provisions of this bill, what would he say to people who actually frame that very differently? And they frame that as the choice to shorten their death. Because these people, in my experience, and I've met many of them now, and I've also met, I've met terminally ill people who, they don't view this as wanting to end their life because they want to live. But the reality is they are dying, and they want to take control over what their death looks like. And how would he respond to that?
Danny Kruger.
Well, firstly, on the point that there's no evidence for causal link between the places that have assisted suicide laws and the increase in unassisted suicide in those countries. I mean, there might not be a causal link, but there's such a clear correlation that it's difficult to understand what else might be going on unless there's something in the water in Canada and Australia and New Zealand and the Netherlands that isn't in the water in other countries. And it might be that those countries have such a sort of disrespect for the frail and the elderly and the ill that people are taking their lives. And I'm afraid to say I do think there is a direct social impact of the signal that this law sends, this law would send into our culture, which is very, very concerning. And to her point about people wanting to shorten their death rather than their life, I hear her use this phrase quite often. I'm afraid to say, and we are here to make law, it is absolutely meaningless. Death happens. You're either alive or you're dead. So people might want to shorten their death. You might use that phrase. What they're doing is shortening their life. There is no conceptual difference. There is certainly no legal difference between the two things. And trying to say that some people's motivation for suicide is legitimate and some people's isn't, I'm afraid to say, makes no sense. What this law will do is allow them to shorten their life. It allows them to have assistance in committing suicide. There is, I'm afraid to say, no other way to describe it in any terms that make sense. So I'm afraid I don't regard the distinction as valid that the Honourable Lady makes. Right. Let me go on. The obligation, I think, that we have to ensure that this bill sets out what it is claimed that we all want it to do, which is to ensure that people are not pressured unduly into taking an assisted death, does, I think, oblige us to put that in black and white. The Honourable Member from Rother Valley said that the current term is more than enough, and we've had a bit of an exchange about that. I would emphasise the point that it is a clear principle of the statutory interpretation of law that courts will look not just at the words that are in there, but the words that are not in there. And the decision to include some words and not others is regarded as significant by courts. So if the term coercion is there but not influence, then it is appropriate for the courts to conclude that influence was not intended by Parliament. And it might be the case that the term coercion is interpreted to include influence, but if so, let's make that clear. Happy to.
Sean Woodcock.
Thank you very much. I'm grateful for giving way, and apology for interrupting him while he's in full flow. But one of the areas that I've been confused about in this section of the debate is that the Minister has said, and I've known to dispute it, that coercion is clear, and so the courts know where they are with it because they're already dealing with it. But we've also heard in this debate from proponents of the bill that this is about making life easier for the professionals who are involved in this. And that now, I mention because overhanging all of this is the bill as it currently is the path at second reading, which has a High Court judge intervention, but also a suggested amendment that we're told is coming, which will remove that for a potential panel of, say, professionals.
Order, it being 11:25. The committee is now adjourned until 2 p.m. for order.